$13,178.49 due and owing. The business record affidavit also supports the statement of account showing the same amount in the two invoices. The invoices show the goods and also the second invoices for the $500 bond. Exhibit B shows my attorney fee affidavit stating that a reasonable and necessary fee to bring the matter through to conclusion today is $900. I have not seen any written response of any kind from the defendant. I believe our two exhibits establish that there's no material issue of fact and the judgment should enter for those amounts.
And the defendant is a corporation?
Yes, sir.
So under Texas law, unless something has changed, corporations require representation by an attorney. Is that right, Mr. Foley?
That is my understanding, Your Honor.
Mr. McClure, do you have an attorney here with you for your corporation?
I do not currently, but we do have an attorney, but he's in court today.
Okay.
Is it possible to get an extension? We were hoping to go for mediation with this deal.
Your Honor, point out two things, if I may. First, no attorney has filed any answer or appearance in this case for the defendant, so I was unaware of any attorney. And second, we've requested that the defendant mediate this case in the past, and they simply haven't responded to us. So for them to ask today at the motion for summary judgment hearing, I believe is a bit disingenuous.
Mr. McClure, I mean, what Mr. Foley is saying, you kind of put your head in the sand up until now.
Right. Well, I want to say that the letter came in. I had thought the mediation was about a month ago that we received the letter and to make contact. And then we got another deal. And I just thought it was for mediation, but it was for a summary judgment. Because in the first letter, it said that court was Jennifer, like March, sometime like mid-March. And I just assumed we had time for a mediation before that, but it was about a month.
If I may, Your Honor, the March date is the trial date in this matter, and we were just sending notice to the defendants so they were aware of it.
Gotcha.
I'm flexible either way. If you feel like it would be useful to mediate first, Mr. Foley, I'm happy to do that. But you're right, under the rules, they don't have an attorney, they haven't filed a response. You could go forward with judgment and start execution on the corporate assets, assuming that I grant it. But it's, you know the history better than I do.
Sure. Ultimately, I believe my client would rather have some money rather than a judgment. So if you would care to continue the hearing for 60 days, I would generally ask for 30, but with the holidays, I don't know if we could find a mediator so quickly.
Do you want me to call like Burden Mediations and see if they can fit you in this week and I could reset this to next week or the week after?
Let me look at my schedule, and that might be a great idea. Yes, I think that's a terrific idea. I may have to have one of the other attorneys in our firms pinch hit for me, but I think we could do that.
Okay, let me see. Let me just ask, do you have, Mr. McClure, does your corporation have the ability to pay for a mediator?
Well, yeah, I'm sure it shouldn't be a problem.
Let me see. Give me one second.
Karen, may I help you?
Karen, hi, this is Judge Hoffman of the 68th District Court.
Yes.
Hey, we have a mediation, kind of an emergency mediation we'd like to get scheduled this week or next week, and we were just going to see what you might have available.
Well, this week, I have Judge try for today, if that's not too soon. And I also have him available on the 8th.
So today or the 8th, so the PM today or the 8th.
Yeah.
Okay.
And then I have Ken available on the 7th in the afternoon.
Okay.
And then next week, I have Judge Pfeiffer on the afternoon of the 12th or the morning of the 13th. And I have Ken on the 14th for a full day. He's available. And then on the 16th, I have Ken in the afternoon or Judge Pfeiffer in the morning.
Okay. Do you guys, Mr. Foley, would you be willing to mediate with Judge Pfeiffer or Ken Rubenstein?
I'm happy with any of them. I do know that the 16th would be the best date for me out of all those dates.
Mr. Foley, you're kind of cutting in and out. You might want to speak up.
I'm sorry, sir. The 16th would be my first preference. The 8th would be my second preference.
Mr. McClure?
We could do the 8th. We could do any day but the 16th, but the 8th would work if that's
So, so Judge Pfeiffer is available in the morning or afternoon on the 8th. Is that correct, Ms. James?
Yes.
Do you prefer morning or afternoon?
Afternoon, sir.
Afternoon.
perfect.
All right, so let me kind of explain this, Ms. James. So this is a case that is set for summary judgment. The defendant is a corporation. They don't have an attorney, but they say they have assets, and so or they claim to have an attorney. The attorney hasn't made an appearance, and so if they don't pay, then please let us know. They've said they can pay and they will pay. And the cause number on the case is DC 21-14783. And Mr. McClure, what is your email address? And Rhonda, if you could get this down too, what is your email address?
Okay, it is TMCCLURE.
Did you get that, Karen?
Then .swsm@gmail.com.
That was the defendant, and the plaintiff's attorney is Lawrence Foley.
Lawrence Foley.
FA. It's on the website, but yeah, Foley. FA.
Okay. And I didn't get all of Mr. McClure's. I got McClure, and then I got the last part of Gmail.
So say the middle part again.
Okay, it is TMCCLURE.SWSM as in Mary @gmail.
Okay. And what was his first name, please?
Tommy McClure.
Okay.
And the defense attorney's email address is lawrence@barnettgarcia.com. The
Is
plaintiff's
that Lawrence LAW or LAU?
LAWRENCE@barnettgarcia.com.
Okay, thank you. And the cause number was DC 21-14783.
Let me a second. DC 21-14783, correct.
All right, and we're going to do this on the afternoon of the 8th.
Correct.
Give me just a few minutes and I'll get all the notices sent out.
Thank you, Ms. James. You have a great day.
You too, thank you.
All right, bye.
Who did you want to put down as the mediator judge to get an order?
King Pfeiffer. And we're going to reset the summary judgment on this to December 19th at 10 o'clock.
Okay.
All right, guys, good luck. I hope we work it out. And Mr. McClure, I will tell you, this is kind of your last shot. So you need to see if you can't work it out.
Okay, thanks so much. Appreciate. Hey, just a quick question. How much is mediation usually roughly?
600 usually.
Okay.
Do you know how much he is these days, Mr. Foley? I don't know, 500 or 600.
That sounds about right to me, but I don't know for sure.
It's gone up since I mediated. So I used to go to mediations. So it's been a while. All right. Good luck, guys.
I appreciate your efforts today, Your Honor. Thank you.
No problem. And we reset this to the 19th at 10 o'clock. via Zoom. All right, next case we have is Casey versus Myers Secondary. Anyone here on that case?
Yes, Your Honor. Brandon Fuqua on behalf of plaintiff Kevin Casey.
Your Honor, David Kassab on behalf of defendant Amir Miraskandari.
All right, let's go on the record on DC 205795, Casey versus Miraskandari. Counsel, make your appearances.
Your Honor, this is Brandon Fuqua of DLA Piper on behalf of plaintiff Kevin Casey.
Good morning, Your Honor. This is David Kassab on behalf of defendant Amir Miraskandari.
So we have two summary judgments set for today, is that right?
Yes, Your Honor.
Yeah, Your Honor, I think ours was not the attorney's fee summary judgment motion. We did not get a hearing until 11 o'clock today, but we would like to take it up now if Mr. Fuqua does not have any opposition and the court is able to.
Let's see what we can get done. I have quite a few hearings at 10, so we'll just get as far as we can. And then we may have to take a break at 10.
Understand.
We'll try to do both. I've read everything, so you guys don't really have to go into a lot of detail, but whatever you guys want to argue, I'm pretty familiar with this case and pretty sure of what I'm going to do, but let's go ahead and go forward.
Okay. Thank you, Your Honor. So as you know, right around 2.5 years ago now, plaintiff sought a simple declaratory judgment. The parties had entered into a settlement agreement. Defendant had breached that agreement, and plaintiff simply sought a declaration that defendant had breached it and an injunction that he not do so again. The court granted that. Right around a month ago, the court granted plaintiff's motion denying defendant's counterclaim as to one breach, and the summary judgment before you today simply seeks a take-nothing judgment as to defendant's sole remaining counterclaim that plaintiff has breached the no litigation provision of the settlement agreement by just simply trying to enforce the settlement agreement. By the clear language of the agreement, it contemplated that the parties could enforce the settlement agreement through litigation. That's exactly what we're trying to do. We're not seeking any other relief other than to enforce the judgment. The court's done that now. So we think that defendant's counterclaim is either a stalling tactic or simply a further dilatory move. The arguments that defendant raised, we think, one, have been disposed of by the court previously, such as that by a separate entity filing a compulsory counterclaim relating to a separate settlement agreement in Harris County Court at Law, that did not breach the no further litigation provision. And certainly by trying to enforce the settlement agreement in this case, that itself did not either breach the settlement agreement. And so we're simply looking for denial of defendant's remaining counterclaim.
Thank you, Your Honor. So the no further litigation provision is essentially a covenant not to sue, and that's just a promise not to pursue any further litigation. And the language of the provision was very clear. It said that the parties will not file or cause to be filed any claim against each other. Mr. Casey could have carved out and put in their language that said relating to enforcement of this agreement like he did with other provisions, but he did not do that with that provision. And the case law is clear, and the restatements are clear that a covenant not to sue can prohibit future claims. And that's exactly what this one does by having the language that
this is just your client kind of unilaterally decide not to make the remaining payments under the settlement agreement, right?
Your Honor, that's never been in front of the court, the remaining payments issue. They have never filed a pleading that has brought a claim that Mr. Mirskandari did not make a remaining payment. What they did was file a motion.
So that's the fundamental issue I guess I have, Mr. Fuqua, is did you guys plead this or not? Because
yes, Your Honor. So we asked for a declaration that that defendant breached the settlement agreement. The court granted that, gave us the declaration, and there was an entered agreed judgment that was contemplated by the settlement agreement. So this was not a breach of contract. This is entry of an agreed judgment. And so the whole purpose behind when the parties entered into the agreement was that we would not have to get into a contractual dispute about whether there was or was not a breach, that the parties agreed that should defendant, as a matter of law, fail to make a payment by a date certain, then plaintiff could go to the court and seek entry of the agreed judgment. That's what we've done here. And so we think that I would agree it's not properly before the court because the court's already granted us that relief. And so the argument that there should be some additional language in the settlement agreement that would give us the right to enforce it, I think is already there. There's no magic language, and even as the precedent, it was either precedent from the Third Circuit or unpublished Houston Court of Appeals opinion that I think are distinguishable that defendants cited. None of those cases stand for the proposition that we were required as some kind of magic language to include in the settlement agreement that we could enforce it. In fact, the settlement agreement by its very terms included language that contemplated that the parties would enforce it. Defendant makes an argument that we have to look only to one paragraph of the contract, and if we don't see a provision there, then the contract fails, but that's just not how our precedent works. We look to the four corners of the contract, we look at it in its entirety. And there are not just one, but several provisions of the settlement agreement drafted by the parties that contemplates that any party could go to Dallas County District Court and seek enforcement of the settlement agreement. That's exactly what we're doing. We're not trying to have a complicated matter going into breach of contract or not. This is simply as a matter of law, the parties agreed to the settlement agreement. We're trying to enforce that agreement. And unfortunately, after 2.5 years, we're still trying to do that same thing.
Your Honor,
anything else, Mr. Gasab?
Yeah, Your Honor. A couple of things. Number one, counsel didn't tell the court that the $75,000 issue was only raised recently in a motion to enter judgment. And that motion was completely improper because Mirskandari had revoked his consent to the agreed judgment. And by revoking his consent to the agreed judgment, they had to file a claim in a pleading to enforce that. And they never did that. They never had any pleading about breach of the $75,000 payment. And so rather, they just filed a motion to enforce an agreed judgment that had been withdrawn. And so, you know, that's issue number one with regard to the breach of contract claim. The essence of their claim is that Mirskandari breached the contract by filing a allegedly disparaging statement in the Harris County lawsuit a couple of years ago. That's what the essence of this claim was. They asked for declaratory relief that Mirskandari breached the non-disparagement provision of the settlement agreement. And it was our contention that by filing this lawsuit, it violated the no further litigation provision because it made clear that a party will not file or cause to be filed any claim, and it was unlimited. And to the extent that counsel wants to say that other provisions in the agreement contemplated suit, those are later provisions in the agreement. And as the court knows, specific provisions control over general provisions, and the earlier provisions control over latter provisions. And so if he's arguing that these other provisions made the no further litigation provision enforceable by filing suit here, then it's at least ambiguous. And if it's ambiguous, it becomes a fact issue for the jury. And so we don't think summary judgment is proper with regard to that. Secondly, Your Honor, there's two claims that I understand that they moved for summary judgment on relating to the breach of the no further litigation provision. And the second claim was the counterclaim that Amir filed, arguing that Mr. Casey breached the no further litigation provision by having his entity, Jinsoon, file a claim against Amir's brother, Aladad. And I didn't hear any argument by Mr. Fuqua on that, but it's our contention that the court's previous order did not address that. And so, I'd be more than happy to get into that. I think when we were here at the last hearing, the court had made a comment that it did not think that Aladad was an entity under the meaning or affiliated with Mir Iskandari under the terms of the agreement. Your Honor, we've cited some case law and various definitions of what affiliate is, and we think it certainly includes a brother. And so we think that under the language of the agreement, Mr. Casey breached the no further litigation clause by filing or having Jinsoon file that counterclaim. And so we think that summary judgment's improper on that as well, Your Honor.
All right, I'm going to go ahead and grant summary judgment. Have you submitted an order on this, Mr. Fuqua?
Yes, Your Honor.
I didn't see it on here. Let me go ahead and share screening because I don't see an order. Maybe I'm missing it. When was the order filed?
It was filed on November 10th, 2022.
Okay, let me make sure I have the right one.
And if it,
I'm not saying you're wrong. I need to get to it. Let me see. Is it this one here?
yes, Your Honor.
There's quite a few different judgments. Yep, I think this is it. Okay, do you want to do the other one now?
Yes, Your Honor, I would like to.
Okay, let's go ahead and proceed.
So, Your Honor, this is a summary judgment that we filed on defendant's claim for attorney's fees. The defendants have either in their pleading or in the motion to enter the agreed judgment made a claim for attorney's fees under both Chapter 37 and Chapter 38. We don't think attorney's fees are proper under either section. For attorney's fees to be recoverable under Chapter 38, Casey must have recovered damages. He's recovered no damages in his claim that Mir Iskandari breached the settlement agreement by making allegedly disparaging statements. So we don't think that attorney's fees is permissible under that section. With regard to Chapter 37, a party may not use that chapter as a vehicle to obtain otherwise impermissible attorney's fees. And we cited the MBM Finance Corp versus Woodlands, Texas Supreme Court for the proposition to show why Mr. Casey's claim for attorney's fees is improper. And in that case, the Texas Supreme Court held that when a claim for declaratory relief is merely tacked on to a standard suit based on a matured breach of contract, allowing fees under Chapter 37 would frustrate the purpose and limits imposed under Chapter 38. And so, Your Honor, we think that Casey's claim for declaratory relief is duplicative. He essentially argues, and you heard counsel say today, that they wanted a declaration merely that Mir Iskandari breached the settlement agreement. And that is very analogous to the one that was made in MBM, where they wanted a declaration that the parties, it was kind of the inverse, but MBM wanted a declaration that they complied with its contractual obligations. And the Supreme Court held that a declaration could not support a fee award as a matter of law and denied fees. And so we think that under that reasoning, as a matter of law, Mr. Casey is not entitled to any attorney's fees under Chapter 37 or under 38. So we would like summary judgment on that issue, Your Honor. Thank you.
So, Your Honor, plaintiff's original petition sought attorney's fees only under Chapter 37. We did not seek it under Chapter 38 then. We are not seeking attorney's fees under Chapter 38 today. However, we obtained a declaration that defendant had breached the contract 2.5 years ago. And since that time and up to that time, we incurred substantial attorney's fees. And so we're trying to recover attorney's fees, Your Honor, not relating to anything other than our obtaining the declaratory relief, and that is permissible under Chapter 37. I think that when Mr. Kassab just mentioned that this case is the inverse of MVM Financial that he cited, he's exactly correct. In MVM Financial, the Texas Supreme Court held that you could not obtain Chapter 37 and Chapter 38 attorney's fees at the same time for the same relief. That's not the case here because, again, we're seeking attorney's fees only under Chapter 37. That is permissible under statute, and Mr. Kassab has not cited any precedent to the contrary. I think it's emblematic of the fact that this litigation has been going on for so long due to defendants' numerous pleadings and appeals that's the very reason why we're seeking those Chapter 37 attorney's fees today. It's because just obtaining a simple declaration that defendant has breached the contract and getting them to pay that has...
Did you plead that you were seeking under Chapter 38? He says
no, Your Honor.
Your Honor, if you go to page 6 of his motion for summary judgment, motion for entry of agreed judgment and fee application where they were seeking fees, he says, quote, Casey is entitled to recover his reasonable and necessary attorney's fees pursuant to Chapter 37 and 38 of the Texas Civil Practice and Remedies Code, end quote.
And if you go to our original petition that was filed on April 17th, 2020, it states that we are seeking Casey's entitled to recover his reasonable and necessary fees under Chapter 37.
Mr.
In our response,
why did you say in your motion or response that you were seeking it under both? Was that just a mistake?
It was a mistake, Your Honor. In the response, to this motion.
This is what I'm going to do. I'm going to, as to Chapter 38, attorney's fees, to the extent it's ambiguous, I'm going to grant summary judgment. You can't pursue those. As to Chapter 37, I'm going to deny summary judgment. Mr. Folkwood, go ahead and, how do you say your name? I keep butchering.
Fuqua, Your Honor.
Fuqua, sorry, Fuqua.
No problem.
Mr. Fuqua, if you could go ahead and prepare an order that details that, share it with Mr. Kassab, and try to get that to me by tomorrow morning. At the beginning of the order, make it clear that this was heard. So instead of on this date, but on December 5th, 2022, submit the order, and I'd like it to be emailed to Rhonda by this afternoon.
Will do. Thank you, Your Honor.
All right, guys, have a great rest of your day.
Thank you.
Thank you, Your Honor.
Thank you, guys.
Okay, Judge, I have the attorney logging in now and regarding that trial for tomorrow.
Sure.
That's Mr. Attorney Ramos.
Morning, Your Honor.
Where is Mr. Perez going to sign on, or what's going on?
I just spoke to him on the cell phone. He's trying to sign on as we speak.
Okay. We have a ton of hearings at 10 o'clock, so if we can fit you in before then, it will save you a lot of time, because if he doesn't get on quickly, then you may be waiting for 30, 45 minutes or an hour longer. So
I'm trying to call him right now, Judge, because I'm not quite sure what's going on. Let me see if I can get him on here.
As you can see, the room is filling up again.
Mr. Perez, the judge can hear you. We're trying to do the hearing real quick, okay?
Yes, ma'am.
Judge, he can hear you. Can you hear him?
Yeah. So you guys are set for trial tomorrow. You're number one.
Go ahead and have a seat. It's on Zoom.
Oh, it is.
Wait, what's going on, Rhonda? Is there somebody there in person?
Yeah, Mr. Ramos is here in person. He has another hearing at 10 o'clock. He's
Okay.
somewhere.
You have time to go back, you go through the room right over there, you can go in.
Okay.
But who is Gary talking to?
I think he's talking to a jury that's lost because the door is open.
Oh, okay.
She's leaving, Your Honor.
All right. Sorry about that.
Sorry
Okay.
about
Mr. Perez, can you hear us?
Yes, Your Honor.
Okay. So you guys are number one, set for trial tomorrow. it looks like the case we had from last week is going to carry over. It's looking pretty likely that's going to happen. And so I was going to give you the option, if you want me to just reset you to next week, you would be number one next week. Or I can have you come in tomorrow and you can just ride the docket until this case is over. I thought it might be more convenient if you do it next Tuesday.
I don't know if you know, I filed a continuance yesterday based on my illness. I came down with the flu the day, Thanksgiving Day, and I've been home in bed since. Okay? I am getting better,